So with that said, I'm going to hand it over to Caroline on our team, Caroline Lumpkin. She's going to introduce our speaker.
Thanks, Jennifer, and hello, everyone. My name is Caroline Lumpkins, and I'm the ELSI Research Associate for the NBSTRN and serve as the staff lead for the Bioethics and Legal Work Group. I'm very happy to be here to introduce Ed Goldman, who will be providing an update on the Michigan lawsuit and will share his expertise and answer some of your questions. His talk is the first installment of an upcoming series of talks and webinars from the NBSTRN covering various ELSI topics relevant to NBS research. So with that, I'm excited to introduce you to Ed. Edward Goldman has extensive experience in the realm of health law and practice as it pertains to peer review, licensing, and malpractice, and brings more than 30 years of bioethics experience. Ed created and continues to serve on the University of Michigan Pediatric and Adult Ethics Committees. His work focuses on embryonic stem cell research, newborn screening, and the intersection of law and medicine with a special attention to reproductive justice issues of informed choice. He has published in medical and legal areas such as privacy, public safety, medical education, and informed consent. Ed is a member of a national commission focusing on the research use of newborn screening dried blood spots and is the president of the State of Michigan BioTrust, which manages the research use of dried blood spots from the State of Michigan newborn screening program. He serves as a co-chair of NBSTRN's Bioethics and Legal Work Group and is a member of the Clinical Integration Work Group as well. So thank you very much, Ed, for being here. I'm going to turn it over to you.
Thank you. So what I'm talking about today is a Michigan lawsuit called Kaniszewski versus the State of Michigan and the Michigan BioTrust. It was filed in 2018, February of 2018. It is a federal case, and it claims that the State of Michigan and the BioTrust violated search and seizure laws, violated constitutional rights of privacy, and that therefore the dried blood spots should not have been obtained and should not be retained. That goes to the heart of newborn screening, and it also goes to a research question. In 2000, the State of Michigan passed a law that said the dried blood spots from newborn screening should be retained and should be used for research with confidentiality. So the idea is you take the dried blood spots, you de-identify them, and then you can use them for epidemiologic and other research. It is both newborn screening and the research use that were initially the subject of this lawsuit. The lawsuit was brought by an attorney called Phil Ellison. Phil is an attorney who makes his living bringing lawsuits where he can try to get legal fees if he wins. So it's not that he's a real big proponent of newborn screening, it's just that he saw an opportunity here. How did he see that opportunity? Well, his wife gave birth to a baby after 2010, and she was asked to sign a consent form shortly after childbirth. And Phil, being an attorney, said, hey, wait, nobody can sign a consent form right after you've had a child. You're a little discombobulated right then. The consent form was the Michigan consent form allowing retention and use of the dried blood spots from newborn screening for research purposes. So Phil brought a lawsuit. The lawsuit was assigned to a judge called Judge Ludington, Federal District Court. Remember, the federal system is District Court, Court of Appeals, United States Supreme Court. Judge Ludington looked at the case and by August 8th had written an opinion dismissing the case. What he said, and this is no surprise to those of you who are used to public health issues, is that newborn screening is a public health program. It doesn't need consent at all in order to take the dried blood spots and do a screening to save children's lives. And so he threw that part of the case out. He also said that the research seems appropriate. The state of Michigan passed a law, and it is up to the plaintiff's attorney, Phil Ellison, to prove that there is no state compelling interest. The state said our compelling interest is we have this treasure trove of data. We should use it to improve the health of the citizens of the state. So Judge Ludington threw the case out and also awarded us, the defendants, attorney fees. This made Phil a little cranky since he makes his living getting attorney fees, not giving them to other people. So he immediately appealed. And when I say immediately, I mean within 40 minutes of the time that Judge Ludington's opinion was issued. The appeal was to the Sixth Circuit Court of Appeals. Those of you who are legal groupies know that the Sixth Circuit Court of Appeals is a very conservative appellate court. The Court of Appeals, June 2019, reversed Judge Ludington in part, saying that the samples were okay for newborn screening. In other words, the Court of Appeals agreed that newborn screening is a public health program and should be retained and doesn't need consent, but that if you are also going to use the samples for research, not a clear public health issue, you do need consent. So what had we done? Well, Michigan had retained samples all the way back to 1984. When the state of Michigan changed the law in 2000, they said, going forward, we ought to have informed consent. Going backward, we can't have informed consent, so we will have an opt-out. The problem with opt-out is people have to know they have a right to opt out, and it's difficult to know that because you don't really get any notice about it. The state of Michigan then took its own time to figure out the consent process. So the law was passed in 2010, 10 years later, the Michigan Department of Public Health finally figured out how they wanted to do consent going forward. So since 2010, everybody has been asked for consent. As Ellison points out, they're asked in a kind of vulnerable period, but they are asked for consent. Consent is obtained. Now, consent, you can look at consent two ways. One way is sort of the classic consent that we're all used to when we have a healthcare procedure. Somebody says, I want to do a bronchoscope. I'm going to stick something down your throat. I can puncture something. I can rupture something, but I need to do it to make the following diagnosis. Here are the risks. Here are the benefits. Here are the alternatives. Do you consent? That's sort of healthcare consent. This consent was an IRB, an institutional review board, a research consent, and it is broader. What it says is there's no real risk to you because we have de-identified the samples. There's no direct benefit to you, but we can use these samples to do some research which may benefit society in general. We can't tell you exactly what kind of research we're going to do because we don't know. 5 years from now, somebody might come up with a great idea and want to use these dried blood spots. So it is a more generic consent approved by an IRB. Sixth Circuit didn't quite understand research consent versus healthcare consent. They sort of lumped them all together. So the case went back to Judge Ludington. In the meantime, as some of you probably know, there were cases in Minnesota and Texas resulting in the destruction of dried blood spots from newborn screening. There were also cases in Indiana and in Nebraska where the court held that newborn screening was a public health program and that the samples could be retained. There has never been a lawsuit like ours where the research issue is involved. So the case went back to Judge Ludington. Judge Ludington gave the attorneys time to file motions. The state filed a motion and the plaintiff filed a motion. The state motion is, we hope, Judge Ludington, that you will understand the difference between IRB approved consent and healthcare consent, and that you will understand that the consent we are getting, which was approved by the state's IRB, is a valid research consent, and that you will let us use the dried blood spots at least since 2010 for research. And you will also let us use the dried blood spots from before 2010 because we are giving people the opportunity to opt out. And although we don't have consent, the IRB waived consent for those blood spots. Now, one thing you have to understand, this is not a class action lawsuit. It is a lawsuit for 10 families. 2 of them have children born before 2010. The other 8 have children born after 2010. While we are just focusing on that, we are also worried that Phil can bring a lawsuit and call it a class action and try to deal with everybody in the state, not just these 10 families. So we're having to think about those issues as well. So our motion, the biotrust motion and the state motion, is please, Judge Ludington, say that our consent is adequate for both newborn screening and research purposes. Ellison filed a motion saying that the consent for research is no good. It's done at a bad time. It's not specific enough. It doesn't really say what the purpose of the research is going to be, and therefore it is not sufficient. So that is a main issue. There are no trial dates set yet. The judge said that he would decide these motions actually next week, August 16. So I'm sorry we're doing this week, but by next week, I might have an update. If I do, I will let Carolyn know, and she can send that out to everybody. Following the judge's decision, then we have to decide if we can settle this case or if we're going to go to trial. The state said it would dispose of anything that had identifying information on it, so that all the blood spots that we have will be de-identified. The only possible problem with that is, what if we have an unintended finding that is of clinical significance to a patient? If everything's de-identified, we won't be able to find the patient and let them know. And we brought that up. Ellison said, I don't care. I want everything de-identified. And the state said, well, if you don't care, we don't care. If it helps us get closer to a settlement of the case, that's fine. So there is a very slight possibility that someday we might find out something that we want to tell somebody and we won't know who they are. So really, there are 2 questions left. One is, how long should we store these spots? So far, the state says we're going to store them forever. Ellison says forever is too long. You should only store them for 10 years. And so we're fighting about 10 years, 20 years, 18 years, 17, yeah, you know. The advantage of having them, of course, is we've been able to do some very interesting research. I'll just tell you about 2 very quickly. One, we took a bunch of spots when we still had identifying information, compared them to death certificates of kids who were alleged to have died of sudden infant death syndrome, SIDS, and found out that using modern newborn screening, half the kids who were alleged to die from SIDS actually died from something that we are now testing for in newborn screening that we weren't testing for 20 years ago. So that is an interesting reason for keeping some identifying information, but that's not going to happen. The other case that we're doing, the other research study that we're doing right now, is we are taking zip codes. We still have zip codes, even though we don't have identifying names. So we're taking zip codes that are adjacent to Lake Superior where allegedly people eat a lot of whitefish. And we're looking at the newborn screening from 1995, 2005, 2015 to see the level of mercury in the blood of newborns and see if it's going up, so that we can at least generically tell people who live near Lake Superior or who eat a lot of whitefish that they should be careful about that because of the mercury content in the fish. So those are two studies that we've been able to do. We have explained both of those studies and some others to Judge Ludington, and he is impressed with the fact that we are using the dried blood spots for legitimate research. So 2 issues left: duration of storage and adequacy of consent. The court has, as I said, no problem with post-2010 research. So we, at the least, we will have 10 years of records. Hopefully we will have records going all the way back to 1984 when this case is over. It is, one other thing I want to say, the state law says if you don't like the fact that we are retaining your samples, even if you gave consent, you can withdraw that consent at any time. All you have to do is let us know. We said to Ellison, you know, all of your clients, if they're upset and they're worried about their privacy, just say the word and we'll destroy their blood spots. And Ellison said, well, no, that will make my case moot. I don't want to do that. The judge understands, because we did all this in front of the judge understands how disingenuous that is. Here's an attorney arguing privacy is so important. We say you can protect privacy by telling us to remove the spots. And he says, oh no, then I won't have any lawsuit left. So hopefully that will all get factored in. We will know better the 16th when the judge renders his opinion. I am talking fast. I know that. I apologize for that, but I wanted to leave time for questions, and I have to get out of here by 2:30. So let me stop at that point and see if people have any questions or anything I can give you more information about.
Well, thank you for the information you presented. It's been very informative and getting us up to date. I just want to let everybody know if you have questions, we have a few that are in the chat, questions and comments in the chat box. And then if you want to ask your question, just you can either raise your hand or unmute yourself and ask it in person. I had one question that I wanted to start off with. So they're getting rid of the dried blood spots that have the information, the identifiable information. So can the state of Michigan still, so it sounds like this is going to impede the state of Michigan to use this for quality assurance purposes. So validating new testing methods, is that the case? And was that information presented to the judge?
No, I think the judge is going to allow them to keep identified dried blood spots for 6 months for quality assurance and testing related to the newborn screening program. What we had done is create what is called an honest broker system, so that there are 6 dried blood spots. The state would retain 1 with identifying information, would give us, the BioTrust, the other 5. Both of those would be barcoded, so that we could say to the state, we have barcode 1, 2, 3, 4, 5, 6. You know who that is. We don't, but we need to tell them something. Can you tell us who it is? Or in the case of my example about the SID study, we have barcode 1, 2, 3, 4, 5, 6. We don't know who that is. You do. Can you send us their death certificate redacted? So it will eliminate that.
Okay.
Which is too bad, but it is what it is. Okay. Let me see. So there's a question, why did they decide on 10 years? We have not decided on 10 years yet. That's just Ellison's number, and it really is just Ellison's number. We are arguing that that makes no sense. If samples are de-identified, There's no privacy issue with 10 years, 15 years, 20 years. It doesn't matter. So we're waiting for the judge to decide that issue. If spots are de-identified, won't patients be unable to opt out later? That's correct. And we've raised that with the judge as well. Ellison says, as long as the spots are de-identified, nobody needs to opt out because you'll never know whose spots they are. But frankly, somebody might say, I just don't want you to have my spots. So it's an issue, but I think the state is just going to say, look, we're not going to keep any identifiers.
I think
What about
Michelle,
known positives for specific disorder? Yeah, exactly. That's why we would like to keep identifiers.
Michelle McClure has a question.
Yes, please.
Raise her hand.
Yeah, so Michelle McClure with ACMG. I was just curious if the Michigan law requires consent in general, or if it specifies informed consent, and really what kind of impact does saying informed consent versus consent make in these types of cases?
So the Michigan law says consent, not informed consent or informed choice. And by consent, the Michigan law means a consent approved by an IRB. I see Deborah has a question.
Sorry, I'm trying to unmute myself here.
Yeah.
So my comment is, as you know, Texas has been through some of this previously, but we continue to get requests about blood spot usage for either children that have died at some point or children, or like we got one for CMV, congenital CMV just the other day, but we continue to get requests for usage of spots from the individual consented. This is the individual consents to have their spots used for whatever they want it used for. And they're destroyed. They never gave consent to begin with because we're an opt-out state. And there has been a lot of devastation in those families that have requested their dried blood spot because of the only time you could diagnose something or other is in the newborn, or that's the only biospecimen left of the baby or the adult, or well, not quite adult, of the child or whatever. And so I was just wondering if that was considered in all of the, let's say, arguments in front of the judge about the usefulness of being able to identify it later by request if you've been given consent.
Yeah, thank you, Deborah. That's a very good question. And what it demonstrates is the lack of knowledge of the plaintiff's attorney about newborn screening, and frankly, the lack of knowledge by both the judge and the Sixth Circuit about newborn screening. If you really think about it the way Deborah has just outlined, it's important to have information because God knows what you're going to want to ask about in the future. If your focus is privacy, then your focus is de-identify, de-identify, de-identify. And the problem with that is it doesn't really show an understanding of the science. So you're exactly right, Deborah. But one of my frustrations over my professional career is as I learn more and more medicine, I get more and more frustrated with the inability of the legal system to come to real grips with the implications of the science.
Yeah.
You have a follow-up?
Yeah, no, I just wanted to correct. We're an opt-in state, not opt-out. So then to keep it, I realized I said opt-out. Oh, no. We're
opt-in, opt-out. What's it? Right. And you had that terrible lawsuit.
Melissa Parisi had a question that kind of is on the same lines about Debbie, about the possibility of a countersuit from a family that could argue that the anonymization process takes away their potential for future suit. You were kind of talking about that. Is that still a possibility?
Well, it's a great question, Melissa, but some family would have to know about the existence of this lawsuit. They would have to hire an attorney, they would have to pay that attorney, and they would have to bring that claim, or they could file an amicus brief. I mean, if some family came to me or to the state and said, wait a minute, this is crazy, we would urge them to either try to intervene or file an amicus brief. Amicus simply means friend of the court, to say to the court, listen, we don't want to be de-identified. We want to have the opportunity to be able to either withdraw in the future or get clinical information. No one has come forward like that yet.
Well, you were
So
talking,
yeah,
Ed,
go ahead,
about that.
Melissa.
Yeah, I was just going to say, to follow up, you were talking about the cases of, I presume, kids who were ultimately diagnosed with like MCAD deficiency,
Yeah,
and in fact died, were quote unquote SIDS. And you read these horrible stories in the newspaper about parents who are accused of child abuse and then only get exonerated in those cases where there might be a blood sample available and someone was able to make a metabolic diagnosis. So, in those cases, those people were able to pursue this and knew about their dried blood spot, and conceivably could make a pretty compelling argument for why keeping the spots and being able to link them in these sorts of extreme situations is so valuable.
right. That's exactly right. And Ryan says, do you want such a family or individual from Michigan to contact you? Sure, that'd be great. It's egoldman@umich.edu, or just let Carolyn know if you know a family. I think those are the kind of issues that lawyers and judges just simply don't understand, and that we do.
I know we're almost
That's
at
my
your,
medical side, we, not my lawyer side, we.
yeah, I know we're almost at your we're at 2:28, and I don't
Yeah.
want you to miss your meeting, but thank you. Talk has been great because you've highlighted the research implications of this lawsuit, as well as the other health medical implications that a lot of people aren't really thinking about with this. So thank you so much. If we get any more comments or questions, Ed will have Caroline contact you so you can follow up with us. So if you guys have any more questions, you can enter them in the chat and we'll make sure we get it out.
Yeah, and let me just say quickly, Carolyn already said it, but Aaron Goldenberg and I are co-chairs of the NBSTRN Ethics Committee. So if there are general ethics questions, we're happy to hear about them.
Yes.
And we got 1 minute left. Carolyn, what were you hoping I would say that I forgot to say?
I was just hoping that you'd be able to respond to the community's questions, and I think that you did that. I think that there's a lot to say about what this means in other states moving forward. Does this mean anything? But I think it's a lot of, like you said, we'll see what comes in the next few weeks. But I just wanted to say thank you for being here, and I know it's a tough time for you, so in scheduling. So
No, happy to do it.
Yeah.
All right, thank you all. If you have questions, just let Jennifer or Carolyn know, and I'll be glad to respond.
Thanks so much, Ed.
Thank you, Ed. And thank you guys for all your great comments and questions. And, in addition to any questions about this topic, if there's other topics that are related as far as ethical legal issues that you would want to hear on this call, please reach out to myself and we can try to come up with a speaker to talk about these type of issues. I also, since I know Jalili, you put this in the chat, you can also unmute yourself if you want to talk a little bit more, but he was asking a question about getting the correct information in the New Steps tool as far as the state retention times.
You covered it all. Thank you.
A lot of
Appreciate it.
people responded and their information is up to date, so that's good, or they're going to update their information, so that's really great.
And